The Companies Amendment Ordinance 2018 was passed by the Legislative Council and was gazetted on the 2nd of February. It has commenced to operate on the 1st of March, 4 days ago. Why do we have this amendment ordinance? The FATF, under its Recommendation 24, requires members' jurisdictions to have in place a mechanism for ensuring that there is adequate, accurate, and up-to-date information on the beneficial ownership and control of companies that can be obtained or accessed in a timely manner by competent authorities. As you have heard Margaret said, Hong Kong is a member of the FATF. So the amendment ordinance, again, is a measure taken by Hong Kong to fulfill its international obligations to combat money laundering and terrorist financing. What does the amendment ordinance do? To put it simply, it requires a company incorporated in Hong Kong to identify its significant controllers and to maintain a significant controllers register. It amends the Companies Ordinance, Chapter 622, by adding a new Division 2A to Part 12. Division 2A has 37 sections, ranging from Section 653A to Section 653ZK. The amendment ordinance also adds 3 new schedules to the ordinance, Schedules 5A, 5B, and 5C. So specifically, which companies have to keep a significant controllers register? Division 2A uses the term applicable company. In effect, all companies formed and registered under the Companies Ordinance or a former Companies Ordinance have to keep a significant controllers register. And that would include companies limited by shares, whether public or private, companies limited by guarantee, and unlimited companies, whether public or private. But it doesn't include listed companies. This is because listed companies are already subject to stringent disclosure requirements under the Securities and Futures Ordinance. Let's take a quick look at a list of the major requirements imposed on an applicable company by the amendment ordinance. An applicable company is required to keep a significant controllers register, to take reasonable steps to identify its significant controllers, including but not limited to the giving of notices, which we will consider later on, to enter the required particulars of its significant controllers in the register, to keep the required particulars up to date, and to allow law enforcement officers to inspect and make copies of the significant controllers register. So you may wish to note that the law does not require a significant controllers register to be open for public inspection. If a company fails to comply with these requirements, the company and each of its responsible persons commit an offense, and each is liable to a fine at level 4. that is $25,000. And where applicable, there is a further daily fine of $700. If you own a local company, you should by now have a significant controllers register. Otherwise, you might have committed an offense. Let's look at the requirements one by one. Section 653H subsection 1 provides that every applicable company must keep a significant controllers register, even if it does not have a significant controller. The significant controllers register, just like the register of members, must be kept in either the English or Chinese language and kept at the company's registered office or a place in Hong Kong. The company must notify the Registrar of Companies the place where the significant controllers register is kept. And if there is a change in that place, the registrar must also be notified. Section 653I provides that a significant controllers register of an applicable company must contain the following: the required particulars of each of the company's significant controllers, the particulars of a registrable change in respect of each of those significant controllers, the name and contact details of a designated representative, and the additional matters specified in Schedule 5C. So under no circumstances should a significant controllers register be empty. A significant controller means a registrable person or a registrable legal entity. To be a registrable legal entity, there should be three elements. First of all, it has to be a legal entity, and it doesn't include a corporation so, by the definition of the term legal entity in Section 653A. Secondly, it has to be a member. In other words, a shareholder of the company. And thirdly, it has significant control over the company. A registrable person means a natural person or a specified entity that has significant control over the company. A specified entity means any of the following: a corporation sole, a government of a country or territory, or part of a country or territory, an international organization whose members include 2 or more countries or territories, or their governments, or a local authority or local government in a country or territory. If in the course of investigation, a company has reached and identified any of the foregoing bodies, the company may simply enter the specified entity in its register as its registrable person without the need to look further for a natural person. According to Section 653C subsections 2 and 3, a natural person or specified entity that has significant control over the company is not its registrable person if the person or entity holds shares or rights in the company through its registrable legal entity, which has any of its shares listed on the Stock Exchange of Hong Kong. What does that mean? It simply means that if a company has a registrable legal entity that is listed on the Hong Kong Stock Exchange, it is not necessary for the company to look beyond that registrable legal entity to trace whether or not there is a registrable person in respect of the shares or rights held by the registrable legal entity. And that's the only exception. In all other cases where there is a registrable legal entity, the company must continue to explore the chain of ownership to find out whether or not there is a registrable person behind that registrable legal entity. So how does one determine significant control? A person has significant control over a company if the person meets one or more of the 5 conditions in Part 1 of Schedule 5A. The conditions are: Condition A, the person holds directly or indirectly more than 25% of the issued shares of the company. In case the company does not have a share capital, it means the right to share in more than 25% of the capital or profits of the company, as the case may require. Condition B, the person holds directly or indirectly more than 25% of the voting rights in the company. Condition C, the person holds directly or indirectly the right to appoint or remove the majority of the board of directors of the company. Condition D, the person has the right to exercise or actually exercises significant influence or control over the company. And condition E, the person has the right to exercise or actually exercises significant influence or control over the activities of a trust or a firm that is not a legal person, but whose trustees or members satisfy any of the first 4 conditions in relation to the company. Part 2 of Schedule 5A contains provisions for the interpretation of the schedule. The Significant Controls Register, as we have said, must also contain the name and contact details of a designated representative. Section 653(c) provides that an applicable company must designate at least one person to assist law enforcement officers in relation to the Significant Controllers Register. A company must not designate a person unless the person falls within one of the following 2 categories. The first category includes a member, a director, or an employee of the company that is a natural person resident in Hong Kong. The second category includes an accounting professional, a legal professional, or a TCSB licensee as defined in the Anti-Money Laundering and Counter-Terrorist Financing Ordinance, Chapter 615. Schedule 5C has set out 9 scenarios, such as where the company knows or has reasonable cause to believe that it has no significant controller, or where the company's investigations are still ongoing. A company is required to note in its register all the matters in Schedule 5C that are applicable to it. Before we move on to the next requirement, I would like to mention that all entries in relation to a significant controller in the register may be destroyed only after 6 years from the date the person ceased to be a significant controller. Companies are required to take reasonable steps to identify its significant controllers. Reasonable steps include reviewing documents and information readily available, such as the company's articles of association, the register of members, and any shareholders' agreement. Under Section 653P, subsection 2, a company is required to give notice to a person if the company knows or has reasonable cause to believe that the person is significant controller. The notice has to be given within 7 days of such knowledge or belief, whichever happens first, and the notice must accord with Section 653Q. Under Section 653P, subsection 3, a company must also give notice to a person if the company knows or has reasonable cause to believe that the person knows the identity of someone else who is the company's significant controller. Again, the notice has to be given within 7 days of such knowledge or belief, whichever happens first, and must accord with the requirements under Section 653R. It is, however, not necessary to give notice under Section 653P in the following 2 situations. The first is in relation to a registrable person, and that is, the company has already been informed of the person's status as being its significant controller, and all the required particulars have been provided to the company by the person or with the person's knowledge. The second situation is in relation to a registrable legal entity, and that is, the company has already been informed of the entity status as being its significant controller, and all the required particulars have been provided to the company. After a company has taken reasonable steps to identify its significant controllers and has obtained the relevant information, the company has to enter the required particulars in its register in accordance with Sections 653J and Section 653K. My colleague Angelina will speak more on the provisions of these 2 sections later on. So I'll just skip and move on to the next requirement, the duty to keep information in the register up to date. in relation to a person, there is a registrable change if the person ceases to be the company's significant controller, or there is any change that resulted in any particular entered in the significant controls register for the person to be incorrect or incomplete. Under Section 653T, an applicable company must give notice to its significant controller if the company knows or has reasonable cause to believe that there is a registrable change with respect to the significant controller. Again, the notice has to be given within 7 days after the company first has notice or reasonable cause to believe that there is a change, whichever happens first. And the notice must accord with Section 653U. You will hear more about the requirements under Section 653Q, Section 653R, and Section 653U from Angelina later. It is not necessary to give notice under Section 653T in the following two situations. The first is in relation to a registrable person, and that is the company has already been informed of the change, and the information has been provided to the company by the person or with the person's knowledge. The second situation is in relation to a registrable legal entity. That is, the company has already been informed of the change. A company must make available its significant controllers register for the inspection and making of copies at any reasonable time upon demand by an officer of the company's registry for ascertaining whether the statutory requirements relating to the register are being complied with. It must also make available its register for inspection upon demand by a law enforcement officer in performance of a specified function under the law of Hong Kong. As I have said at the beginning, the register is not required by law to be open for public inspection. Furthermore, the meanings of law enforcement officer and specified function are defined by the law. You will find a definition for law enforcement officer under Section 653B, which covers, for example, an officer of the Customs and Excise Department, an officer of the Hong Kong Police Force, or an officer of the Inland Revenue Department. And of course, it will include an officer of the company's registry. Specified function means a function relating to the prevention, detection, or investigation of money laundering or terrorist financing. A person whose name is entered in the significant controllers register as a significant controller is also entitled to inspect the register free of charge and provided with copies of the register at a prescribed fee. It is an offense if any person knowingly or recklessly, in purported compliance with a notice, makes a statement or provides any information that is misleading, false, or deceptive in a material particular. It is also an offense if any person knowingly or recklessly makes a statement in the Significant Controllers Register that is misleading, false, or deceptive in the material particular. A person who commits any of the above offenses is liable on conviction, on indictment, to a fine of $300,000 and imprisonment for 2 years, and on summary conviction to a fine at level 6, that is $100,000, and imprisonment for 6 months. In closing, I would just like to remind you once again that a local company, unless exempted, must keep a Significant Controllers Register, irrespective of whether or not it has a significant controller. And that register must not be empty. Thank you for your attention.